Folks, welcome to the Overby Center for Southern Journalism and Politics. Our program today is on the Voting Rights Act of 1965, but we'll also deal extensively with Mississippi's new voter ID law. And before I introduce our guest panelists, let me provide a little background for the discussion. The Voting Rights Act of 1965 is widely considered one of the most effective pieces of civil rights legislation ever enacted in the United States, and possibly one of the most controversial, at least in the South. Aimed specifically at the South, it eliminated things like literacy tests, which were traditionally used to restrict voting by African Americans, most of whom had not been allowed to vote since Reconstruction in places like Mississippi. It authorized federal registrars to go in and enroll voters in states where fewer than 50% of eligible voters were registered or had voted. Eventually, the law required the Justice Department to clear any changes or restrictions in voting. So if a state wanted to do something a little different, it had to go to the Justice Department and the federal courts first. It changed the political landscape of the South and Mississippi. Mississippi now has more black elected public officials than any state in the Union. Last year, the Supreme Court struck down the pre-clearance clause after effectively pulling the enforcement teeth of the law. Justice Roberts said that after 50 years, it was unfair to target specifically the southern states, that discrimination in things like voting was rare nowadays. And after that decision, Mississippi implemented a much publicized voter ID law that requires voter identification at the polls. Now, let me introduce our panelists. Mississippi's Secretary of State, immediately to my left, Delbert Hosemann, a Republican and Ole Miss graduate, is serving his second term as Secretary of State. He championed the voter ID law as a way to combat election fraud and is leading a statewide campaign to make sure that free ID cards are available to any voter who wants one. Dr. Leslie McLemore, to his left, there's no political imagery intended by having Dr. McLemore to the left of State Hosemann.
That's where I belong.
He was president of the Jackson City Council, and he served as acting mayor of Jackson. A retired graduate school dean and political science professor at Jackson State University. He's a veteran civil rights activist, and also served as interim JSU president and as director of the Fannie Lou Hamer Institute. Jim Herring is a Canton attorney and former state appeals court judge. He chaired Mississippi's Republican Party for 7 years and served on the Republican National Committee. He also served as chairman of the Republican State Chairman throughout the United States and its territories, and wherever he goes, music plays. Dr. Marvin King, on my far left, an assistant professor of political science and fellow of the Residential College, has written extensively about racial polarization in the electorate, representation of the black electorate, and race in the aftermath of Hurricane Katrina. He also teaches courses on Southern politics. That's quite a crew. Thank you, gentlemen, for coming. Let's start by framing the significance of the Voting Rights Act here in Mississippi. What did the law mean to Mississippi when it was enacted? Dr. McLemore?
When the law was enacted in 1965, can y'all hear the echo out there? Maybe they can stop the echo, because I don't want to hear myself twice. You don't hear it? Okay, all right. If y'all don't hear it, that's good then. How many of you are journalism majors or politics majors? Wonderful. How many of you have heard of V.O. Key Jr.? Okay. All right, students, I see some of you did bring pencil and paper, okay? So V.O. Key Jr. wrote a book called Southern Politics in 1949. I think it was published maybe in 1950. The classic work, earlier work on politics in the American South. V.O. Key's book sort of captured the essence of the southern states. And of course, he was writing before the passage of the 1965 Voting Rights Act. But he was writing during the time of Smith versus Allwright. How many of you have heard of Smith versus Allwright? Okay. Smith versus Allwright outlawed the white primary. So if you don't know that, just sort of write it down and Google Smith versus Allwright, not while you're listening to us, but when you leave here, and you'll get some sense of sort of the Southern setting. In 1945, that was the end of World War II. The question was about the impact of the 1965 Voting Rights Act, and I'm slowly getting there. The end of World War II. The end of World War II was significant for a lot of reasons. Obviously, it ended the war, the soldiers came home, started careers, et cetera, et cetera. But also something very significant happened to the veterans. The black veterans came home from World War II. Some came back to South Carolina and Georgia and Louisiana and Texas, and obviously some came back to Mississippi. There was one in particular that came back to Mississippi by the name of Medgar Evers. After having served in France and other places in Europe, came back to Mississippi, continued his education at Alcorn A&M College, where he graduated from high school, then from college, and got involved in the civil rights movement after he graduated from Alcorn and after selling insurance for a period of time in the Mississippi Delta for a man by the name of Dr. T.R.M. Howard, who started the Regional Council of Negro Leadership in the Delta. From 45 through 1965, the struggle for voting rights in Mississippi was an ongoing one, fought primarily by the NAACP under the leadership of Medgar Evers. And Medgar Evers was appointed field secretary, the first permanent field secretary of the NAACP in 1954. That was significant because Evers becomes the first full-time person who was working on issues of civil rights and voting in Mississippi. A veteran of World War II, had seen the world and wanted to change Mississippi. In 1946, there was a guy by the name of Theodore Bilbo, who was in 1946 a U.S. senator, had been governor. And in 1946, let me just share with you students, because some of you older people have heard this, but on blacks and voting, I styled it here. A famous Mississippian said in 1946, quote, "I am calling upon every red-blooded American who believes in this superiority and integrity of the white race to get out and see that no blacks vote. The best time to do it is the night before the election," end of quote. That was Bilbo's position on blacks voting in 1946. This is 1 year after the end of World War II. This is 1 year after Medgar Evers had re-enrolled at Alcorn A&M College. The position that Bilbo took in 1946 represented the primary point of view in Mississippi about blacks voting in this state. So the struggle from 45 to 65 was one of blacks engaging with their white allies, engaging in the struggle around the right to vote. So the 1965 Voting Rights Act, in my judgment, was the most effective piece of social legislation passed in the history of this country. Gave black people the right to vote. When I registered to vote in DeSoto County in 1962, I had to take the literacy test, I had to pay the poll tax, I had to interpret the Constitution to the satisfaction of Ham Ferguson, the register in DeSoto County. And I was one of a handful of blacks in 1962 that registered to vote. There was one man in my home county, Mr. Green, who voted after World War II. And the record has it that he was the only black person in DeSoto County registered to vote from the 40s until I registered to vote with my late brother and my college roommate in 1962. And the efforts beyond that. My grandfather, who died in 1968, voted for the first time in 1967, and he died at the age of 79. So voting in the black community in Mississippi was not widespread. So the 65 Voting Rights Act changed that. And as Bill pointed out, we have the highest number of black elected officials of any state in the nation, except maybe Georgia or Michigan. Georgia maybe. But the point that I'm really trying to make is that it had a tremendous impact upon people registering to vote. That's a short answer to a long question. So let me stop.
Okay. Dr. King, you want to add to that?
Sure. Thanks for having me. I appreciate it. So the 65 Voting Rights Act, up until last year, the 2013 Shelby County decision was, as Dr. McLemore says, the most significant piece of civil rights legislation as it relates to voting. It completely changed the playing field. One thing I like to tell my classes is that you cannot help yourself politically as an individual or a group if you don't have access to the polls, if you cannot vote. So voting is political self-help. So until the 65 Voting Rights Act came, African Americans largely lacked the ability to engage in political self-help. And the 65 Voting Rights Act changed that. So from the perspective of that, any effort to dilute or take the teeth out of the 65 Voting Rights Act is something that, in essence, is looked at through the lens of making it more difficult for people to help themselves politically.
Let's talk about the pre-clearance clause for a minute. Jim, when the pre-clearance clause was pretty controversial in the South. Why did state officials throughout the South dislike having to go to the Justice Department for advance approval before doing anything on?
I would say primarily because every time that they wanted to change a voting precinct or anything else, they had to go to Washington to get pre-clearance or get it pre-clearance from a federal court. And so it hampered the local officials from being able to do the things that they felt was necessary to meet changing times and to do the things that are necessary for self-governance. I would like to respond, if you don't mind, to that history lesson that Dr. McLemore gave us. And I was privileged when I was state party chair or Republican chairman to be invited to his political science class a few times and enjoyed it very much there at Jackson State. And that was the first time some of his students had ever seen a Republican. But I enjoyed it and I appreciated the dialogue with him, and he was always very respectful to me, and hopefully an exchange of ideas, possibly with really not so much differing philosophies on what has occurred in the past, what the aftermath was, or whether it was needed. I don't know that we have that much difference at all on any of that. What we differ about today, perhaps, is what do we do going forward? Or is the 1965 Voting Act something that could never be changed in the next 200 years? The Supreme Court of the United States says that when they took away equal sovereignty for certain southern states in particular on the voting rights issues, because of the bad things that occurred in the past. They're giving those states and others across the country an opportunity. They're giving us, as Mississippians, both blacks and whites, an opportunity to see if we can get beyond that and put race in the rearview mirror on all these issues and give us an opportunity to govern ourselves, and every time we want to change a precinct, that we don't have to go to the Justice Department in Washington. I would like, if you don't mind, the doctor mentioned some books. I would like to mention a book that I sort of have read over the years about what happened back during that period, and I'm old enough to remember some of it. Was Parting the Waters by Taylor Branch. I think I found that to be a great book, accurate book on many of the bad things that happened across our country, particularly in the South and in Mississippi during that period of time. And it talked a lot about voter fraud. Voter fraud, when people left to their own devices. And I would say that in my judgment, and I applaud our Secretary of State for everything that he's done to try to make our elections fairer and equal for all of our citizens. And I think that voter fraud is still alive and well in this country if it goes unchecked. And voter ID, in my judgment, is one way to check voter fraud. But I think Parting of the Waters is the best book that I have read on that period. And I have a couple of other books here I'd like to mention to you. One is about Jimmy Carter. When he first ran for the state Senate in Georgia, he was a victim of voter fraud, and he had to go to court to get his, the ballot box was stuffed, and he had to go to court to declare himself the winner of his first state Senate race, his first elective office. He'd never been president if he had lost that race. And then, of course, you have the Carroll book about Lyndon Johnson. There's a chapter in here they call The Stealing. And, you know, Carroll was the Pulitzer Prize winner that wrote the 4-volume book on Johnson. And how he and his people, he called it the stealing of the United States Senate race in Texas back when Lyndon ran for the Senate and got elected to the Senate on his way to the presidency. The only reason I mention these things is to say at the highest levels of elections in our country, voter fraud is out there. And as somewhere it said in the Bible, Peter said about Satan was a roaring lion. In my view, voter fraud that goes unchecked can be a roaring lion. And anything that we can do, the Supreme Court is giving us an opportunity to govern ourselves. And we should take advantage of that opportunity and see if we cannot, working together, take those shackles off to where every time we want to change a precinct in Madison County, Mississippi, we have to go to the Justice Department in Washington. That's sort of where I'm coming from about all of this, and I hope I'm not stepping on into the lines of my Secretary of State, whom I admire very much.
You know, in Washington right now, there is a move by a small bipartisan group, I would call it an uphill move, to pass a new Voting Rights Act that would meet the requirements that Justice Roberts laid out in the Supreme Court opinion, majority opinion. It would initially apply to 4 states, including Mississippi, and provide ways for states to get out from under the thumb of the law, say if you go for a certain number of years without any serious complaints. And also other states, not in the South even, could be pulled in if they have a spate of complaints over a period of time. Secretary Hosemann, do you think we need a new Voting Rights Act with pre-clearance clause?
Well, I think first you need to get back and get the facts straight here. The Supreme Court, the Shelby County case that y'all have all discussed and heard discussed here, only invalidated one section of the Voting Rights Act. That's Section 4B of the Voting Rights Act, and that was the percentage test. And it said in there that if less than 40% evolved to less than 50%, less than 50% of your minorities were registered to vote and participating in the elections, that standard was not constitutional, and they used several different arguments about that. But in the end, it wasn't necessarily the discriminatory practice that it applied only to a few states, but it was the fact that it didn't apply to all of the states, and the test itself was outdated. That was the biggest part of the Supreme Court's decision. What these percentage tests that they had used and had used since 1968 didn't apply, and as you heard Professor McLemore discuss just a minute ago, those percentages don't apply in Mississippi any longer. And in the Supreme Court case, Shelby case, they specifically discussed the fact that Mississippi had 6.7% of African Americans registered to vote in 1965, a distinct minority. That now has climbed to 77% of African Americans, a percentage which is higher than Caucasians actually registered to vote in the state of Mississippi. So the percentage test really doesn't apply anymore, and it was not applied equally across the board. So to address this, and I happened to speak with Senator Leahy just last Thursday, Senator Leahy introduced a bill along with some bipartisan support to go back and reconstitute these tests. But as it's reconstituted and proposed, it has a number of different flaws in it, and that would discriminate in a fashion that would allow only 4 states to be qualified. Those are, if during the last 15 years you had 5 or more violations and of the section of either section 14 or 15 of the Constitution, which is equal protection on 14, and of course 15 that says minorities cannot be discriminatory in their voting patterns. So it first outlines a test that would apply to only 4 states, exactly what the Supreme Court asked them not to do in the first place. And then secondly, it gets into a couple of discussions. The new act gets into a couple of discussions, but one of the criteria is that the Attorney General believes that there might be discriminatory intent by some state law or whatever, and therefore he can, by his own solicitation, without any court review, can declare Mississippi or any of these other states to go back to pre-clearance, which is exactly what the issue was when we started the whole matter. There are holes in the new law that I don't think would pass constitutional muster again. As part of that, they grandfathered in photo ID, which we're going to talk about photo ID in a second, was grandfathered in the new legislation in an effort to get it through the United States Congress. The voting rights violation definitions in here are very problematic and not well defined and subject to interpretation by the Attorney General, whether they be Republican or Democrat. The second thing that is unusual to me, and I can't understand why they would do this, they say if you have a low minority turnout, that means African Americans don't go to vote. And minorities are defined as Hispanics, African Americans, or any one of 2 or more races. In our country now we have very, very many marriages that are biracial. So those individuals would also be considered minorities under the new act. Those individuals, when you look at this minority, if they don't go to vote as much as the Caucasians or the non-minorities vote, or if they're less than the average of the whole nation, then they get thrown into this pre-clearance. So in effect, we've turned pre-clearance somewhat into a whether or not minorities vote or not. Now they may vote more if there's an African American for president, or they might vote less if they don't like the nominees. So it's a very unusual test that the Congress is trying to come up with. But at the end of the day, to get the facts straight, Mississippi in the last 15 years has had 7 violations. Those violations are one of which was statewide when they had the legislature attempted to require the election of boards of supervisors, the head of the superintendents of education in various precincts. Justice Department objected to that, and it never came into force and effect. The other violations, 5 of those violations were city violations. The city of Clinton, city of Kilmichael, and others where they tried to allegedly gerrymander a local alderman election. If any of these come into fruition, then the whole state is subject to preclearance. Even though the state may not have had any problem, and the city of Kilmichael is probably several hundred souls, that would throw Mississippi back into preclearance for all 276 municipalities in the state of Mississippi, even where we have just those 3 violations. So they have gone back, and the last of those 5 violations, 1 statewide, 5 were local cities like Kilmichael, Clinton, and a couple of others. And the 7th one was the case in which an African American discriminated in Knoxville County against Caucasian voters, where we had reverse discrimination, where it went the other way. And that case would be counted against the state as well. It seems to me when we get back to this, clearly to me, and 15 years, by the way, is the only way we get this. There's like 2 or 3 of these cases in 1992. If they went back 10 years or 5 years, Mississippi would not qualify under the new statute for the Voting Rights Act. So it seems as if it was styled just far enough back in order for us to be covered under the Act. It has a lot of issues in it that are problematic for, I think, for the state of Mississippi. We should have the Voting Rights Act applied equally across the entire country. There shouldn't be discrimination, just not only in these 7 states or the 39 other counties that they picked. And when they go back to try to gerrymander this and come up with these violations for a longer period of times where one small subdivision of a state can cause the whole state to get subject to preclearance, or the Attorney General, whether they be Republican or Democrat, can take the issue and make a determination that a whole state should be into preclearance. That's not judicial reform, that's not judicial or equal application of the statute. So the Voting Rights Act amendment, when Senator Leahy spoke just this past Thursday and had a conversation about this, the actual adjustment that we go forward and we ensure that minorities are not discriminated against has not been changed, either in the 14th or 15th Amendment or in Section 2 of the Voting Rights Act. None of that was changed. The only issue here is the preclearance formula and whether Mississippi ought to be covered. And in that instance, I would only ask that Mississippi be subject to the identical requirements of any other state, and that we be looked at on a reasonable time frame and not half a century ago or others where we had obvious issues in Mississippi, obvious and horrible issues regarding our voting. So that may be more than you want to know, but that's how the new Voting Rights Act sets up.
Justice Roberts, in his opinion, the Alabama opinion, said that while they were changing, ruling certain portions of the Act, Section 4, unconstitutional, it invited the Congress, if they wanted to come up with some additional formula. And I guess that's where this comes from. And it was interesting to me, Mr. Secretary, that the violations we're talking about, so many violations within so many years, the great majority of those were what the Attorney General said was a violation unilaterally, as opposed to it being a violation through some court edict.
And that's correct. A lot of these talk about final adjudication. So if the Attorney General of the United States makes a determination that some aspect of Mississippi or some small towns was a violation of this act, that stays until final adjudication through the Supreme Court. So it would be in effect for years without having a hearing, as opposed to having a hearing first to see if there were imminent problems or there were issues that would be involved. This one allows them to put us in preclearance, and we stay in the Supreme Court forever. I want to talk just a second and give you all an observation about these observers. The new civil rights, the amendment to 2014 allows for observers to come to Mississippi, and I think this is important. Back when Leslie was struggling so hard to be able to even cast a ballot in Mississippi, federal observers started coming in after the 1965 Act. Under the new law, the Attorney General can continue to appoint federal observers. To give you some facts about that, When y'all hired me 6 years ago, I started asking for Federal Observer reports. They come every election, every federal election in Mississippi. I said, I want to know where we're messing up, what the problems are. Would you give me those? The Department of Justice has refused to give me those. I then went to the United States Attorney for the Northern District and the Southern District. I asked both of them to please get copies of these observer reports that they come to these elections, and they send. I usually get a note about the day before our election saying we're sending 10 federal observers, 15 federal observers, and I started our own program. Before I came in, no Secretary of State had ever been in a precinct. We now have been in almost 1,000 precincts in the last year. We have 1,800 of them in Mississippi. I send our people out sometimes to 50 and 100 every election. So I bumped into these federal observers out here. And so I ask them, you know, we have our people ask them, what's going on? Do you have any questions? They quiz some people that exit the polling places. But we ask them, you know, please give us a report. Tell us if we're doing anything right or wrong here, what needs to be done. No report has ever been received by me nor made public to anyone else in the last 6 years that I've been here that outlined even one instance of any discriminatory practice in Mississippi. Had there been one, I tend to think we'd have heard about it. But not only will they keep it secret from you, who pay for them, y'all are the taxpayers, not only do they keep it secret from you, they keep it secret from us. We can't find out. I, on the other hand, have published a election day report every year since I've been here. It's on my website, you can go see it. And I discuss issues in there about absentee ballot fraud, other issues, every one of them that we go to. That lack of transparency by the federal government is very troubling to those of us who try to administer the election in a non-discriminatory practice, in a non-discriminatory manner. But that being said, I'll turn it back. I think you had one other thing before we get too far in here. I know we want to
Yeah,
see questions.
I would like to get the voter ID by 11:40. It'll give us 10 minutes for that discussion.
I can do that.
Wait a minute, hold on just a second. We've got about 4 minutes. Marvin, real quick.
Sure.
Pre-clearance.
I'd like to touch on a few of those things. You know, first of all, as far as transparency, federal government, you know, sunshine and transparency, I can't speak to all the things that Secretary Hosemann spoke about, but you can look at the 2006 proceedings in Congress when a unanimous Senate, I think the vote was 98-0 and 394 or something in the House when they reauthorized the Voting Rights Act for 25 years. And you know, typically the Supreme Court defers to the legislature on these issues. That report was over 15,000 pages, and it documented more than 1,000 instances of challenges using Voting Rights Act challenges for reasons why the Voting Rights Act needs to be left as is. Since 2006, I know there have been over 30 challenges that have gone up to the DOJ, Department of Justice, where they have affirmed those challenges. Now, one of the things about the Shelby decision is that, yes, it only invalidated Section 4, but what Section 4 did is it's what upheld Section 5, the pre-clearance provision. So without Section 4, you really couldn't have a Section 5. The reason Section 5 was so important is it put the burden on the state. And what that did is, what many people believe, is it kept the state from acting, the state and or its local jurisdictions, from acting in a way that would invite scrutiny, knowing that they would have to receive pre-clearance. Now, if I can channel my inner Ruth Bader Ginsburg in her dissent in Shelby County, she noted how if you're walking outside in the rain with an umbrella and you're not getting wet, you don't take away the umbrella because you're dry. It's the umbrella that's keeping you dry. And in this instance, it was the Voting Rights Act that helped minimize the number of actions that the DOJ got because state and local governments knew that they would have to receive pre-clearance. Another point is equal sovereignty. This was kind of a new principle outlined by Justice Roberts in his decision that states are equal. This was new, and many legal scholars cast doubt on this notion that states are equal. The best precedent for this is the 14th Amendment, which the Republican Congress in the 1860s required southern states to ratify before they could re-enter the Union. So I would cast doubt on the assertion that all states are equal. There's just not a constitutional principle asserting that all states are equal. Another way of looking at it when you're just talking about the numbers is you have to remember that Mississippi is only 1%, actually a little less than 1% of the country's population. So we are going to have fewer, in terms of the grand scheme of things, in terms of the number of raw violations, we only have 3 million people out of 312 million. So we have about less than 1% of the population. So yes, we should have far fewer numbers. And a final point, one of the things that it looks like Justice Roberts is trying to do is we'd call this the effects test. And it's not what was the intent of the lawmakers or what's the intent of the jurisdictions and what they're trying to pass, but what are the actual effects? And that's one thing that that the Voting Rights Act looked at is not necessarily the intent, but the effect. Did the effect lead to have a discriminatory effect? And by trying to move away from the effects test, you're making it much more difficult. You're putting the burden on the plaintiffs to have to prove a priori what the intent was. And that's very difficult because, as some people have said, we don't have Bull Connors anymore running around saying, we're not going to allow this, we're not going to allow that. And so if you can't demonstrate intent because you don't have Bull Connors anymore, and you move away from the effects test, you're making it much more difficult. And so, in effect, it makes it easier to say, well, we're not getting wet, let's get rid of the umbrella. And so the fear is that without the umbrella, you're then going to see more discrimination because states don't have to a priori demonstrate ahead of time that what they're going to do will not lead to discrimination.
Okay, thank you. I want to, and I'm going to come back to Dr. McLemore.
But I just need
Go
to
ahead.
just say, students hearing the Secretary of State and listening to the comments in general do know that pre-clearance is the heart and soul of the 1965 Voting Rights Act. I mean, it essentially gutted what the Supreme Court did. It essentially gutted that great piece of social legislation where we have to reinvent the wheel. And I just think it's important for us to understand that we are now in the year of celebrating the 50th anniversary of Freedom Summer. And some of you, I'm sure, have read something about Freedom Summer. There's a book by a guy named Bruce Watson that talks about Freedom Summer when the young people came from across the country to register voters in Mississippi. I want you to get some sense of the long struggle to arrive where we are now. And when we passed the 65 Voting Rights Act, I didn't have any idea in my heart of hearts that I would be on the campus of the University of Mississippi talking about the fact that the highest court in the land had essentially gutted the 1965 Voting Rights Act that gave my grandfather the right to vote. So, students, you have to read John Dittmer's book, Local People. Write this down to get some sense of the struggle, because the context is important. I mean, I don't have time, we don't have time to go through this long history lesson, but read John Dittmer's book, Local People. And then read one other book by Charles Payne called I've Got the Light of Freedom, that talks about the long struggle, the long road to capture voting rights in Mississippi. Because that story is important in understanding where we are now, because the context is important. We are in a different place, we are in a different environment, but the idea is that if you cannot vote, whether it's 1946 or 2014, it still has the same impact. So I just think it's important for you to realize that the heart and soul of the 65 Voting Rights Act has been eliminated.
Secretary Hosemann, I would like for you to tell us why voter ID is necessary and what you're doing to implement it, if you could.
Well, before we get to that, I want to talk about Les's comment there for a second. When I was a student, much like you, at the University of Notre Dame, I had James Silver as my professor. He was removed from the University of Mississippi and wrote the book, Mississippi, the Closed Society. He was ostracized here by the university and ended up at the University of Notre Dame teaching political science. When I came back, I had a lot of times to sit and visit with him, just one-on-one, in the basement of the Notre Dame Library about this. It is absolutely critical that we understand this history and how we got here, because we can never replicate it. That would be the biggest problem. If when we open that door and leave this room, we make the same mistake again. I have no intention of doing that. And it's just because of the passion that you hear this man and many other Mississippians had to fight to get here. So I think when you look at this process, I want all of y'all to remember the history that he's spoken about. It's so important so that we don't go back. Now, on voter ID, I've got a couple of slides and then we can get to questions, I think. The actual voter ID was passed by the House, sometimes passed by the Senate. It was aggressively fought on both sides, whether we ought to have this or not, for probably 2 decades, beginning in the 1990s. And then in 2010 and 2012, we passed the voting, we got a constitutional amendment. Mississippi had never had a direct democracy where you voted whether or not to have a constitutional amendment since 1890. And so we put 3 issues on the ballots: eminent domain, which was your right for the government to seize your property; voter ID; and the personhood amendment, which is commonly referred to as a right to life amendment. The right to life amendment failed, got 40-something% of the vote. Voter ID got 62% and eminent domain got 72%. The electing process at that time, of course, was the very heavy turnout, election for president, all that other kind of stuff. And so 62% of Mississippians voted for voter ID. And that set us off, and I applied for pre-clearance to the Justice Department a year and a half ago. We met with the Justice Department on a couple of things. After the Shelby County case came to being, states took different ways. Texas, for example, said, to heck with you, we're going on, and we have been denied pre-clearance by the Justice Department, lost a suit, we don't care, we're implementing voter ID. I took a different posture. The day of the Shelby County case, I called the Civil Rights Division, Chris Herron runs it there, and I said, we're leaving our regulations open for the Justice Department. We want your comments. Mississippi has changed. We don't have anything to hide here. And in fact, the Justice Department, Civil Rights Division gave 2 comments, both of which are incorporated in the regulations that I issued last December. This is what an acceptable photo ID is. We accept college IDs issued by the university here, as well as most of the others. Mississippi's is the broadest one of all the states. Here there are student ID, community college, tribal ID, any other branch issued by the government. This is what the voter ID card looks like in Mississippi. It's a voter identification card. A big third of it will be your picture. It has your name, sample, voter man, that's a name and highlights. So when you give it to the individual clerk that's signing you in, it has your county and your address on it. On the back, it has the issuance date. It does not have a date of birth. So you can't use it to get into the library down here and drink beer. All right, this is what the back of it looks like. Photograph, your legal name, legal residence, and all this, and this was approved by the legislature. That's what your voter ID card. How do I get one? Mississippi has the broadest application for any other state. Social Security card, Medicare card, all the federal standards, Mississippi voter registration card, any of the following: utility bills, paychecks, a W-2 form that was one of the forms that was given to us by one of the activists. We consulted 42 different, from the ACLU, the NAACP, to the Republicans, Tea Parties, and everybody else about what should be in here, and this is what came out of it. This is how you get a voter ID card. If you take your mom or dad or someone to the clerk's office, you'll say you don't have any ID card. If you've got a driver's license, you're not eligible. We're only issuing these. Mississippi is the only state. When we had the presidential election, I hired Edison Research. They went and took a poll of 6,000 Mississippians from the coast to Corinth. They did that. I told them I didn't want to know where they were, and only me and one other person knew they were doing that. I didn't want to know where they went or whether. I wanted the demographics to be the same, the percentages to be the same, the age, the economics to be the same as the 2010 census, and tell me how many people went to vote without an ID. 0.8% was the number. And Edison Research does it for the New York Times and MSNBC and everybody else. This is the form that comes out of it where you can sign up and get an ID. We have regional coordinators. We're the only state in the country to ever do this. We have 20 of them out going to every single county looking for people who need an ID. I meet with them every Tuesday morning. This is a video here that we started, and I've got a 30-second thing of that.
Call us and we'll drive you down to the circuit clerk's office for a free photo voter ID. Are there any questions?
Yes. What if I already have a driver's license?
Well, you won't need the new card if you have a driver's license or a U.S. passport, military ID, government-issued ID, an employee ID, a tribal ID, firearms license.
Remember, if you already have an acceptable photo ID, you won't need a new one on June 3rd.
College student ID. Call us and we'll drive you down to the circuit clerk's office and get you a free photo voter ID. Are there any questions?
Yes. What do I need to bring with me to get a free ID?
Well, you can bring your Social Security card, your birth certificate, your Medicare, Medicaid card, voter registration card, utility bill.
Remember, if you already have an acceptable photo ID, you won't need a new one on June 3rd.
A 10-year-old driver's license, a paycheck stub, a government check stub.
Mississippi is the only state that allows that we will pick you up, and we have 400 and something vehicles out here through our MDOT contract. We will pick you up and take you to the circuit clerk's office for free. We're the only state in the country that will look up your birth certificate for free at each and every one of 92 locations in Mississippi. Every circuit clerk's office downtown and everywhere else has one of these. We will look up your birth certificate for free there and provide you a free voter ID. No other state has taken those types of steps, and they're directed specifically at making sure we don't have anybody excluded from the constitutional amendment that was voted in by the populace. So I'll stop on that.
By the way, the people leaving were not leaving in response to the program. They're changing classes, so just be aware of that. We're going over, but I'm willing to go over 2 or 3 more minutes if there are any questions. Anybody in the audience? Yes, sir. Speak loudly.
It's kind of a two-part question, and it's for Secretary Hosemann and Mr. Herring. It's my understanding from the research I've done about the Voting Rights Act that it was designed to not be stale. It was designed to not go out of date, because when it was written, it allowed precincts, if they didn't have a history of voter discrimination over a span of 10 years, to be able to bail out of the pre-clearance requirement. So this is not really about voter IDs, but about the need for the Voting Rights Act. So, I mean, you brought up that Mississippi has had violations. So why didn't more Mississippi precincts? Because it's my understanding that it wasn't the entire state. It was based on individual precincts. So why didn't individual precincts bail out? And then we could just keep the Voting Rights Act. And then the second part of my question is, it seems to me that Mississippi politicians in the state legislature and sometimes Mississippi Republicans are scared of early voting and are scared of, same-day registration and things that would increase voter turnout. So why is it that we're taking steps like voter ID that will probably decrease voting turnout, and why aren't we taking steps like 2-week early voting or same-day registration to expand the franchise instead of limit the franchise?
That's a long question. Y'all understand?
Yeah, man, you need to go into politics. Let's address the second one first, and then we'll address your first question. On early voting, we have been looking at early voting for several years. I think as soon as we implement voter ID on June the 3rd, So I anticipate seeing legislation next year that would allow early voting, probably during the 2-week period before the election. There'll probably be a week when you can't early vote, right, coming into the election, and maybe a 2 or 3 week period out. So about a month out, you'll have 2 or 3 weeks of early voting. Then the last week, when we're getting the poll books together, it becomes very complicated. We have 1.8 million registered voters. We have to print all of that stuff and get it working, usually about Tuesday or Wednesday of the week before the election. So your early voting may be out for the first 3 weeks, and then it'll have a quiet period of a few days, and then you would go on to the next. I anticipate that that'll be favorably considered by me and others next year in the legislation as soon as voter ID is implemented here. And of course, we're waiting if there's possible litigation or whatnot. On same-day registration, that's a disaster. We don't need to do that. And I can take you, if you go look up Cleveland, Ohio's same-day registration problems, or anywhere else's, where we have people that are mobile that could just walk in and say, I'm here from wherever. You could vote here, ride home, vote again. You could do, it's too difficult for same-day registration. Our circuit clerks are not going to support that, and I don't think most of the legislature will support a same-day legislation. Early voting is coming probably this next year. On your first part about bailouts, you're right to a point. The bailout provisions applied to political subdivisions, not to whole states. So Mississippi wasn't able to bail out as such. Each subdivision would have to bail out. And those criteria are still in the Voting Rights Act. They have some bailout provisions that are still in the proposed act and some that were before. Some of our precincts and cities did bail out of the Voting Rights Act and were granted, because they had no history, they were granted the permission to bail out by the Justice Department. Most cities and states don't have enough money to go through a pre-clearance process with the Justice Department just for the heck of it. So many of our cities and whatnot did not apply for bailout. We had some bailouts, and there is a bailout provision in the new act. I hope that covered everything. We can ask others.
One more question, then we got to go. Yes, sir.
This isn't so much a question as an observation that I think the panel would agree with. When we're talking about voter fraud, I think we need to define the kind of voter fraud we're talking about. If you're going to change public policy or legislation, because for example, buying votes is voter fraud, but that has nothing to do with voter ID. I suspect that Senator Lynn Johnson had, in fact, his election was fraudulent.
All of the above.
Problem has a lot to do with buying votes, and I spent a lot of my time growing up in Tallahatchie County, and I can tell you how that's done if anybody. You give somebody a pint of whiskey and a $5 bill and want to be sure they vote for you, there's a way to do it. If you'd like to know, I'll be glad to explain it to you sometime.
I don't want to hear.
Really don't do it. But you need to define what we're talking about, because voter fraud is a lot of things. It's not just somebody coming in and saying, I'm John Doe and I'd like to vote when you're not John Doe.
Well, it includes stuff in the ballot box, includes a lot of things. But voter fraud, of course, is voter fraud. And that's one of the things we're talking about here. But I do understand, Jack.
But you know, the discussions where we have the issue around voter ID or the issue around voter fraud is, if you would look across the country, it is in states where the legislature is controlled by Republicans. You're looking at states where in the last 2 elections, where minority turnout in Mississippi was unusually high across the country. So one really has to systematically look at sort of the pattern, and it seems to me that what is happening, that this is clearly designed to encourage black folk and other minority people from voting, from going to the polls. Let me just say that there are a number of black people in my generation that are intimidated by the process. There are black people in my generation who cannot read well nor write well and are intimidated by the process. Small town Mississippi is not Oxford. Small town Mississippi is not Jackson. Small town Mississippi is not Meridian. There's a whole different animal out there where people are absolutely intimidated by the process. And I think we should fully be aware that we are looking at a systematic pattern across the country where my good Republican friends are trying to figure out a way to discourage people from going to the polls. And I think, quite frankly, we are going to be on the losing side of this battle. 20 years from now, we're going to have a different Mississippi because we're going to have greater participation by minorities, and we are going to have all statewide Republican elected officials. It's going to change. And I just know that what is happening now is a stalling tactic by the good Republican legislators and governors in these states where they are trying to hold on to power. And this is a last-ditch effort. This is really what it is. But America is changing. It's becoming darker. And that means that they're also going to elect some darker people statewide in these states. 37% of the population in Mississippi is African American. There is not one African American statewide elected official. There's something wrong with those numbers. So I'm saying to all of us that we are witnessing a transition in the history of this country. And Mississippi is always last. We're going to come screaming and fighting and clawing, but we're going to change. And it's going to be much more representative of the population and the gender of people that reside in this state.
I know that Dr. McLemore is not questioning my motives.
I would never do that.
And I'm certainly not questioning his. I would just point out to you, voter fraud is not a respecter of color. The Jimmy Carter voter fraud, where the ballot box was stuffed, was handled by Democrats. The voter fraud in the Senate race for Lyndon Johnson, where the ballot boxes were stuffed and the votes were purchased, was all handled by Democrats. In Chicago under Mayor Richard Daley, where they voted tombstones rampantly, was handled by Democrats. That's not to say that Republicans are blameless, but there is no effort here, and I think we'd be doing a great disservice to this elected official here who's bending over backwards. He is charged with us having fair elections for all of our citizens. And the Supreme Court of the United States is giving us the opportunity to try to put race in the rearview mirror on the election issue. And we ought to do everything that we can to try to work together so that we can have equal sovereignty for the first time in 50 years on this issue. It's not what happened then, it's what the issue is now. Where are we going to, can we go forward together and have equal sovereignty and handle our own affairs?
All right, we are way over. I know that Marvin's been straining at the leash. I'm going to let him say something, and then Delbert, if you need to say something, we'll close.
I think Marvin would probably do a great job.
Marvin, go right ahead.
Well, thank you. Just a couple of quick points. The way I see it is the long arc of American history is to make our democracy more open, more accessible, and easier for people to be a part of. If you look at our 14th Amendments, 15th Amendments, 19th Amendments, giving women the right to vote, and then the 24th Amendment eliminating the poll tax, and then the 26th Amendment, which lowered the voting age from 21 to 18. The long arc of American history is to make voting more open, more accessible. So what I think will happen is that the history books will see efforts that make voting harder or create more hurdles. I think in the long run, history books won't look as favorably upon that, because the long arc of American history is to make our democracy more open and more accessible to more people. So we go through these ups and downs, these laws and these regulations. But the long arc of American history is that we reach a more open, accessible society. 20 years ago, nobody would have said that same-sex couples in this country would be getting married. But here we are. You know, this is the country that we are moving to. And I think we're going to see the same thing with voting and any other instance where you have, you know, conflict of this sort of nature. The long arc of American history is that we move to a more open, more accessible, little d democratic society.
Okay, thank you. Folks, I think we owe them a hand.